Thank you. We're going to begin our panel 2, SEC, the red flag. When does a project raise a red flag?
I'd like to thank everyone for being here, and I'd like to thank Baruch College for hosting us again. We're going to start with the introduction, starting with Clem.
Okay, let's see. Who am I? So,
Just read the paragraph.
right. My name is Clem Turner. I lead the corporate and securities practice group at Barr, Smukamal and Kleiner, which happens to be the oldest immigration firm in the United States. So it's fun to lead the corporate group there. I've been in EB5 since 2010. I've represented hundreds of regional centers and projects over the course of those 7 years. My clients have raised probably a couple of $1 billion through the EB5 program in that space. And, my bio's in here, so I'll leave it at that.
Brian?
Yes, you've got my bio in there. I'm the CEO of Icon Compliance Services. We handle investigations, monitoring, and forensic accounting of these EB5 projects. We get called when things go wrong, and sometimes it's pretty nasty when we do get called in, and we have to act very fast by strategizing what we have to do. And the bulk of our staff is former federal agents like myself and federal prosecutors. I'm a special agent who retired from the U.S. Treasury and Homeland Security. And my bio is in there.
Ozzy?
Good morning, everyone. My name's Ozzy Torres. I'm a Cuban immigrant. I grew up in Brooklyn, not too far from here. I started work here in a big firm in New York City. I'm presently in Fort Lauderdale, and for the past 30 years, I've been doing solely corporate and securities work. For the past 6 years, heavily immersed in EB5 work, and I'm very pleased to be here with you.
Sam?
Hi, everyone. Sam Silverman, Managing Partner of EB5 Affiliate Network. We're a national EB5 consulting regional center operator. We have 15 regional centers that cover 21 states, and we work with clients, primarily real estate developers and project developers, looking to structure the full set of EB5 documents for their projects and bring them to market under an approved regional center. Thank you.
And I'm Omar Hakim. I'm the corporate and securities attorney at Mona Shaw & Associates. So we've kind of broken down the program by types of red flags. We've identified 7 different areas that we're going to be discussing. The first area is immigration risk. Basically, the most important thing to any investor is that their investment meets the requirements of the EB5 program. Otherwise, they will not be able to get their green card, which is the entire purpose of making the investment. The second red flag is the EB5 team. So does a person, the economists, the attorneys, the service providers, do they have experience in EB5? The third bucket we're talking about is we identified it as a glossary, basically the certain words that you do not want to see or hear from the promoters. For example, guarantee. There's no guarantees in life, and it's definitely not allowed in the EB5 program. The fourth thing is the marketing and promotion. How is the project being marketed? Intuitively you can kind of tell if someone seems to be honest or if they're kind of using unethical tactics, and we've also identified some specific areas in EB5. The third is structural and conflict issues. Like basically there's many different players in an EB5 project, and what conflicts of interest do those parties have and how are they being managed? And the sixth one is financial controls, which kind of ties into structural and conflict issues, meaning what financial controls are put in place to make sure that there's someone overseeing the money every time it moves from one entity to another, and make sure it's done in a way that's to the benefit of the investor and prevents fraud. And the final bucket we've identified is management, just the background and the reputation of the people actually running the project, and more than reputation, their experience and ability to deliver on what they're on the project they're trying to sell you. So we're going to start with immigration risk, and do you want to kick us off on that?
Sure, thank you. So immigration risks, and I was just discussing with Clem, I'm not an immigration lawyer, but chances are if there's an immigration risk, there's probably a securities law risk. So I'm just going to go through a few of them real fast and then dive a little deeper into some others. So obviously guaranteed return or redemption should raise a red flag. These days, the use of side letters, bridge financing that appears to be too long, a project that's outside the TEA zone should raise a red flag. Tenant occupancy should raise a red flag. A job cushion that's just too tight. Reliance on operational jobs. Now, that may not be an SEC issue, but certainly it's something to look at from the immigration perspective. Of course, outdated TEAs, construction jobs that you're relying on that are over 2 years. Then you might come across some land issues where it's not clear who has title, the title hasn't been transferred, or they're trying to step up the valuation on the land and you don't have a proper appraisal evaluation. That's very common. Let's focus just for a second on really one of the first cardinal sins, which is guaranteed return or redemption. So it was in the matter of Izumi where it was held that, or stated that, to enter into a redemption agreement at the time of making an investment evidences a preconceived intent to unburden oneself of the investment as soon as possible after unconditional permanent residence is attained. So there, it was likened to the person who gets married and puts in writing that they are going to be divorced in 2 years. That's pretty strong stuff, right? So I just read it just a few minutes ago, and I think we should all read Izumi every once in a while because actually it's rich. And it's the heart of this program. And talking about the heart of the program, an esteemed colleague of mine mentioned that, you know, this is about immigration. And yet, Inrei Izumi said, the focus here is on the green card and not on the business. And that's what was found to be objectionable. So let's think about that for a moment, right? This is an immigration program, but the vehicle is a business. And so we need to focus on the business aspect of it. And that's just a sort of, to the extent it's a gem, I just wanted to share that with you. And we can go on to other points now. So the use of side letters. Clem, I'm going to pick on you. Should we allow the use of side letters in SEC offerings?
Well, I don't know if it would necessarily be a red flag, but usually when a side letter is employed, one or a small group of investors is getting some kind of a special deal or a special accommodation. And to the extent that's being used in order to facilitate, I'll say it this way, to the extent that's being used for a marketing reason, they're desperate for investors, and so they're sweetening the pot, so to speak. That can certainly be a red flag to those investors as well as to regulators, that there's some issue with the project.
I would agree with that. I mean, you should always look at anything that smells and sounds like a side letter or something to really think about. I think that's true. Go ahead.
Just to follow up on that, I think what's critical though is the side letter, is it being disclosed to USCIS? Is it being disclosed to a potential regulator, or is the person raising money, is the issuer really attempting to do something covertly? Because I have used side letters, or I have clients that have used side letters, in very transparent ways. I've not had a client try to do something covertly, but I suspect if I do, that would probably not be a continued client of mine.
So we can provide in the PPM that there may be the use of side letters, and that should cure, hopefully, any disclosure issue. But again, we need to remember that offerings should be, right, uniform. And to the extent that investors are getting different deals, that's not so good. Sam, you run a lot of regional centers. Anything that pops out for you?
When we're thinking about risk for projects, we typically look at both immigration and financial risk, right? So on the immigration side, it's really what's the likelihood of the jobs, the 10 jobs being in place for the project, right? And for that to be true, you've got to look at, execution risk. Is it already under construction? What's the likelihood of all the financing coming together? right? Separate from that, you've got the TEA letter and the regional center being approved and active. Those are pretty easy to check, though. It's more of what's the likelihood that this project is going to successfully create the jobs, right? So a safer project is one where it's fully financed, construction's underway, maybe there are already jobs that have already been created. That's going to be a lot lower risk than something that's just a rendering, and maybe there's a letter of intent from a lender, but there's no equity in place or the land hasn't closed. Things like that are going to be red flags for just a higher risk project. Not a project that's not going to be approvable, but just one that's going to be of greater risk, right? And then on the financial side, it's basically, is the capital structure fully capitalized? Is it intact? And is the project totally reliant on EB-5 financing? That's really the threshold issue. If only one investor signed up for the EB-5 in that particular project, you're looking for $10 million, only one person signs up, does the project move forward or not? And how likely or how sure are you that that's true, right? That's really the key question.
And a lot of the immigration risks actually tie into project risk. For example, having a fully financed project, having the project already starting construction, that gives you more confidence that you're going to get your money back and that you're going to get your green card. So next we're going to discuss the EB-5 team. Obviously,
Yeah, the team is important. I'll talk to you guys about team a little bit. And I think the last conversation brought up some technical issues that some of you guys may not be aware of, and maybe the SEC isn't necessarily aware of without drilling heavily down into EB-5. The EB-5 team, frankly, is a very easy red flag that you can identify if the team if the team is inexperienced. And I think first off, an inexperienced team basically signals that the developer or the issuer putting that raise together is being penny wise and pound foolish. As we just talked about, there are a lot of issues that are immigration related that impact the securities work, impact what the economist does, impact the corporate law, and to the extent a team is inexperienced and doesn't know that, you can get documents that are not going to pass muster with USCIS. Also, sometimes inexperienced teams tend to be less diligent on disclosure, less diligent with vetting projects. And these are all top-level things as to why the team matters. However, I can quickly dig a little deeper and explain to you why this red flag should particularly matter to investors and the SEC. The immigration impacts of having an inexperienced regional center or immigration lawyer are obvious, and we kind of talked about them. From a corporate perspective, and Ozzy can weigh in on this, there are certain corporate governance structures that go into place in an EB-5 deal that are not in place in a corporate deal. For example, a prohibition on redemption until the 829 is adjudicated, which an average corporate lawyer is going to have no idea what that means.
Right, so it's not just regular experience. So someone could be doing corporate law for 30 years, but that's not necessarily going to help them.
That's not necessarily going to help them.
And that's where I see some issues, right? Sometimes you have
Right.
big fancy law firms where all of us might have come from, and it's a little troubling that they do great work, of course, but they just don't get certain aspects of it.
Yeah, that's one example. Another example is guaranteeing a redemption. I'm just speaking corporately. Another example is it's very typical in corporate law when funds are paid back to investors that's deemed a return of capital because that has tax advantages.
That's a good point.
Yet a return of capital in EB-5 means all of your investors get denied. So they had great tax treatment, but they have to go home. So an inexperienced team in EB-5 should certainly raise a red flag to those of you who are viewing this as potential investors, but also regulatorily can definitely have impacts. And along those lines, I do have a story about an economist, which I shared with Omar. I had a client a while ago, before USCIS had their own economists. I had a client who had a relationship with an economist that had never done EB5 before, but was a very well-respected economist. And, you know, it's just RIMS too. It's just implant. For those of you who are familiar with EB5, the mechanism in which job creation is formulated is not unique to EB5. So this economist did an economic analysis, and, well, long story short, it was a complete nightmare. USCIS is used to getting the information that they get, the way that they get it, and how they get it. And this economist just used a different format, and it completely confused the adjudicator, and it turned into many rounds of RFEs and a year delay. So, you know, loyalty is great, but, you know, in terms of EB5, it can have real consequences using inexperienced people. From an SEC perspective, the team is usually described in the business plan and or the PPM. It's very easy to see what the qualifications of the team are, and certainly, you know, from an investment perspective, that's a question you should ask. And from a regulatory perspective, you know, I believe that that's something that they look at.
Sam, you have any thoughts?
Yeah, so when we look at project documents as the regional center, we have 15 centers that cover 21 states and probably looked at about 300 or so projects over the last 5 years. It's not, what we see is it's not so much the team members. You often don't find a firm, a law firm particularly, that's, you know, doing their first EB5 offering and is gonna, you know, try to wing it or just, you know, start from scratch. Most of the vendors that we see have done, you know, more than one EB5 transaction, so they're not typically missing like key components or giant red flags that would mess up an investor's trajectory. What we most commonly see are that, you know, a lot of the vendors, securities attorney, immigration lawyer, economist, business plan, all these different companies are all kind of operating in their own silo. They're all separate firms. They're all typically being engaged and working in the project at different steps. And so what we see is kind of number one issue is version control. Just last week we saw, you know, brand name economist, but in the report the regional center name was wrong, the total raise was wrong, and that was because changes had been made since the first draft of the report till when we were provided the final draft. And so not having kind of one person to kind of oversee the different components and that one kind of overseeing person know what to look for, you often have an issue of just, you know, everyone kind of driving on their own parallel path, but nobody really like making sure everything ties, all the numbers and key terms across all the documents. It's a really easy way for USCIS to pick up on an issue when, you know, they've got one total number of investors in one document and it doesn't match in another one, or a name doesn't match. Those are really easy errors to make. So having that kind of one person who knows what they're doing to kind of vet all the final versions, make sure everything matches, that's really the one major issue that we see when we're looking at a new set of documents for a project.
Does this count? I recently reviewing several business plans, and I mean, I'm a lawyer and I probably don't do math that well, but but when I have to foot something and it just doesn't add up, it's just a problem for me. And I've come across that, and that is really a shame.
Moving on to...
Yeah, but they've hired you, Ozzy. So
Yes, I can add. I have a calculator.
Right.
Moving on to forbidden terms and the EB5 documents. Clem, can you talk about how that actually ties into the team and experiences with, you know?
Sure. And I think we got there a little bit already. I mean, Ozzy talked about our probably number one biggest red flag word, which is guarantee. Certainly, the project can get a construction loan guarantee, and certainly the developer can give guarantees with respect to the lending source. But from a marketing perspective, a guarantee that an investor is going to get their money back, or a guarantee that an investor is going to get their green card, it's not only a huge red flag about inexperience on behalf of the people doing the offering, it's also grounds for denial. And it happened. I was at an EB5 conference, walking past a booth and a project. There was someone there that said that they guaranteed to the investor that they were going to get their green card. And I stopped, and then I moved on. But it does happen. It's a huge red flag. Some others that we've also talked about are redemption. Guaranteeing to the investors that they're going to get their money back at a certain date is an automatic denial. There are two more R's that I want to talk about. There's redemption, and then there's the retiring of debt or equity. There is a proper way to do this, and our clients utilize that. However, it must be done in a very specific way. EB5 had to have been contemplated from the very beginning. So if you see in the document that the EB5 money is going to be used to retire a debt or pay back equity, you should be cautious. That's definitely something that you should talk about with your immigration attorney or your attorney to see if that passes muster, and certainly something that I believe the regulators pay attention to. The third R is a rebate in the deal. Or said differently, the issuer is offering some sort of sweetener to EB5 investors in exchange for their investment.
Like a condo at the end of the day?
Like a condo at the end of the deal, which is exactly what I was thinking of. You'll often see, you won't actually often see it in the market, but I think we often see clients who come to us and say, hey, I want to give the EB5 investors, I'm building a multifamily, whatever it is, and, I'm going to give the EB5 investors a discount or a condo or this or that. Those promises are given a value at USCIS, and whatever the value of that is subtracted from their investment. So if they only gave $500,000 and they're given something worth, X, then their investment is 500 minus X.
And even if it's $1, $4.99.99 is not good enough.
Right, exactly. A free pen, like whatever it is, and probably not that crazy.
Yeah.
But be wary of redemption language. Be wary of retiring debt or equity language. Be wary of rebates. Those are big red flags that regulators are looking for, and that investors should treat warily if/when they see them.
But could I add that the anti-red flag in the glossary of words here is fair market value?
Yes, absolutely. You can expand on that.
So I think that, the whole idea about at risk is that the money is just that, at risk. So therefore, if the valuation that you're attaching to a redemption at the end of the day is based upon fair market value, then that should be fine for all purposes.
Mm-hmm.
Moving on, Ozzy, can you talk a little bit about issues you see in the way that projects are marketed and promoted?
So yeah, I wanted to talk a little bit mostly really about so-called sponsors and promoters. So who are those people? Those are the people that are interested in bringing a project on and do the beginning work to get a project off the ground. So there are times when that person, when it comes down to the end of the day, doesn't want to be in the disclosure documents, in the PPM. And Clem, I don't know if that's happened to you, but it's happened to me a couple of times. And what is the problem with that? Well, the problem is that everybody needs to be disclosed that is a key person in an offering. Why? Because we want to know all information that is material to an investor. And if an investor would make a different investment decision if they knew that that person was convicted of fraud 20 years ago, maybe it's not, a disqualifier today, but it might make a difference. Or more importantly, and Clem, I hope you could add on to this, the notion of a bad actor. When we're doing an offering these days, a bad actor could blow the exemption.
Right, absolutely. We use Regulation D and regulation as exemptions for our offering documents. And under the new Reg D rules, a bad actor will make will make your offering ineligible for Reg D, which means no students here on a foreign who are here on student visas, no U.S. persons, and that can definitely have an impact on the project.
Go ahead. Of course, then there's the issue of, part of our main job is actually to kick the tires and conduct due diligence. And you have to be concerned, and maybe this is really in the red flag category, but, slow to respond to due diligence. I mean, what does it take to get information out? And sometimes, that should be of concern. And then there's the issue of commissions and who's going to be earning those commissions, which is also a big issue. But I think that's perhaps enough for this one.
Next, we're going to move on to structural issues and conflicts of interest. Basically, the interrelations of the it's called regional center, NCE or new commercial enterprise, and the borrower or job creating entity. Ozzy, can you also lead us on this topic?
Sure. What we're talking about now is the relationship between the new commercial enterprise and the job creating entity. In the beginning, we can say that there was just a new commercial enterprise, and that entity was both the entity that was used to raise the money and the entity that created the jobs. But I think it was Azumi that permitted a sort of split between the new commercial enterprise and the job creating entity. And when that split occurred, you have the issue of who controls both the new commercial enterprise and the job creating entity. There are times when the same persons, either directly and indirectly, control both of those entities. So in an EB-5 loan model, then you're looking at the situation where the borrower is controlled by the lender and the lender is controlled by the borrower. So it's hard to imagine where you can actually make an arm's length loan. And in fact, when you look at the various cases in this space where there have been issues of fraud, I think you can say almost without exception that they have all entailed commonly controlled JCEs and NCEs. So we wanted to lay that out for you because, well, that is a red flag as well. We wanted to lay that out to you because that is something that you should be aware of. Of course, I think that if people want to do bad things, they're going to do bad things. We do many deals where there is common control, and that's not an issue because they understand that, we have to play the game of at least creating an arm's length relationship between the borrower and the lender. And I think that's achievable. That doesn't mean that we shouldn't look at fixes in order to avoid that problem. And I think the current proposals in the legislature relating to integrity do that. So to the extent that you can, I would say, include an independent loan manager that might be responsible for solely looking after the loan, not necessarily the offering. So you can think about an NCE that is managed by a general sort of manager that deals with everything but the loan, and then the loan manager. Clem, I don't know, or anybody else wants to add something
Brian,
on that.
I know you come into projects,
Yes.
Lots of times assets already had issues, and you do a lot of the forensic accounting. So I think you probably have a lot of experience in seeing conflicts of interest and best practices to avoid those in the future.
We come in after the fact a lot. Of course, we do monitoring also, which is preventive. But the bulk of what we have been doing is responding to these disasters when they do become disasters. And $40 million has disappeared, just as an example, and they can't find the money, and you're getting this forensic calls from the regional center asking where this money went. So we come in, we basically settle down quickly, lock everything down, take all the evidence in, and go through it. And what you find is that a lot of these issues that we've all been talking about were present, but nobody ever detected them, nobody ever looked at them. The conflicts were there, the unlicensed developer was there, nobody ever looked at, or there was a bait and switch. They put somebody in, and then he's really not the developer. Somebody else comes in. Which goes to show you.
seen that too.
You've seen that, I'm sure. But that tells you, just because you're doing that due diligence up front, at the front end, that it shouldn't stop there. There should be continuous monitoring throughout the project, because if they're going to do it, they're going to, of course, they're going to dress up the pig to look good, and then once the due diligence is over, they're going to come in and have another plan.
So whose responsibility is that?
Well, yeah, the lipstick goes off. Yeah,
Whose
exactly.
responsibility is that to keep monitoring?
Well, the monitoring, I think,
Sam?
I think that there should be continuous monitoring throughout the project, and I think the new legislation should be addressing that if it's not. And hopefully we'll get to a point where throughout the project, we will get that monitoring. And let me tell you from the stats, I looked at all the frauds that we have investigated with the EB5 program, and I also looked at the other ones that we haven't. So I combined them. And the bulk of the fraud incidents take place, and you probably have seen this, after the money leaves the regional center and goes to the developer. It just seems to go into a dark hole, and nobody's watching it as to where it goes.
Yeah, that would be a problem.
I think this is I think this is something that the market is aware of. I think starting in 2012, and then it seems almost every 3 to 6 months, there's a new enforcement action. I think the market has begun to be aware that you should look for controls when the lender is also the developer. When he's loaning money to himself or making an investment in himself. And I think over the past couple of years, a lot of solutions have arisen in the industry. And I often advise clients who are in that situation, who are trying to do the right thing. They're certainly not con men, but are setting up their own regional center and want to raise money for their own projects. To pay the extra expense to get a third-party monitor, because it helps you sleep at night. You're not going to ask me complicated questions. In the 11th hour, can we do this? Can we do that? And as a lawyer, I have to figure out what the fiduciary duties are and the duty of loyalty. Just get a third-party monitor, have the question answered, and I frankly believe that the market will reward that as the concept of conflicts gets disseminated out into the EB5 market and to investors who are looking at this. And obviously regulators are wary of completely internal affiliate deals.
I just wanted to add one last point about the loan agreement itself. And so what we need to do, obviously, in that situation is make sure that we have a good loan agreement. And I think that it might be best to get an outside law firm to do that, other than perhaps your corporate and securities attorney, if the deal will support it. But in any event, I think it's incumbent upon all of us to make sure that we have actual good covenants. We have conditions to funding. That's critical. Of course, we need to make sure that we have adequate collateral and that we have perfected or will perfect that collateral.
So how do you stop your client from just waiving all those conditions because they're loaning money to themselves?
That is, I'm just pointing it
out. It's a great document. Yeah, I'll waive this, that, and the other.
Well, I think that would be a pretty clear violation of fiduciary duty. Brian, what kind of financial controls do you suggest putting in place to try to at least mitigate these concerns?
This is a big area, and it goes back to a lot of what I will share with you comes from lessons learned and what should be out there. But financial controls are really the nuts and bolts, what keeps an operation viable and healthy. It should provide a framework of processes that facilitate the attainment of the objectives of the project. These should encompass policies and procedures clearly defined that require the operational procedures should be followed in a certain way so that there's no deviation from those policies and procedures. The accounting system should be clearly defined as to what systems are being used, who's using them, and who are the people who are responsible for handling the documentation of the flow of funds and memorialization of transactions. Segregation of duties. extremely important. A lot of times when we go in and we investigate these cases, when you have fraud, segregation of duties is a huge problem, because you find the same person gets the money, you know, disperses the money, has control over so many things that they could easily commit fraud, and millions could just disappear, and that money's gone, and now you got to go recover that money. So that's a big problem. We talked about the third-party independent monitoring. That's a good control, of course, in projects to ensure earmarked funds for these operations are being spent appropriately and as planned. And I will add this, in our experience from what we've seen, the greater majority, almost all of them, of these EB5 projects that have had fraud in them and that were afflicted by fraud would have been protected had there been a monitoring system in place, a genuine monitoring system. And you know, that you have to be careful. If you're going to have a monitoring team, you know, don't bring in the ice cream man, you know, and his crew. It's got to be, you bring, I mean, I know it's a hot area and a lot of people are jumping into it. You know, make sure these guys are investigators. They have forensic accounting backgrounds. They know how to walk it through the court system. You know, the way we do it, after we do the investigation and write up our findings, we confer with the attorneys on the case and the client. And if the client wants to push it through, we just hand walk it right into the U.S. Attorney's office.
So Ben & Jerry's won't work.
No, I don't think Ben & Jerry's is going to work. No, it's not going to happen. The biggest construction case that we had, you know, that involved, and this raised the bell a little bit. It involved so many multiple companies, construction companies that were so reputable, big names, and you know, we did the investigation. I took the findings, 700 pages. I walked it into Loretta Lynch, and I said, Loretta, here it is. And by the way, that desk that you're sitting on, that's part of the fraud. Her office was affected by the fraud. This is the Brooklyn courthouse. And I said, you know, this is pervasive across the board. And she was pulling her hair out. So we got to be a little skeptical about the developers, no matter who they are, because it's commonplace. So that's an issue. And you know, the monitoring, I think, is a huge control that can alleviate a lot of that.
Yeah.
Yeah,
so
I was just going to say, to the point I made earlier, which I don't think I made that well, with Ozzy's point, with getting a real loan agreement. Getting a real loan agreement is the first step, but doesn't get you all the way over the finish line, because if it's still an affiliate deal, it's possible to waive these conditions. It's possible to undo like what's on paper, but a third-party monitor, someone who can actually enforce what's written with teeth, is it goes a long way to giving assurance to regulators, and should give assurance to investors as well.
And you said something about, I'm sorry, about what's on paper. One project that we did was a luxury hotel in Florida, and not far from Mar-a-Lago. It was.
But not Mar-a-Lago.
Yeah. So they had the developer, and they had these names on paper that were submitted to the USCIS. Everything looked great, but in fact, the brother, who was a convicted criminal who had been doing this over and over again, had used his brother to be the straw man, who had no record, and that's
an EB5 case?
That's an EB5 case, yes. So these things can happen. But when you said on paper, I just wanted to bring that up.
So,
I just wanted to make a positive note, which is that, you know,
This is the red flag.
the SEC, the SEC does a lot of work, and you know, you catch some things and you miss some things. But I would have to say and hope that the vast majority of deals are fine, but unfortunately, you have some bad actors.
So moving on to management, Brian, what do you really look for in a management team? And then specifically, how do you make sure that the management team on paper is actually the management team that's running the project, especially for an investor that...
Right. And this ties into the last topic that we just talked about, because we hit on that a little bit. For consideration of red flags, you know, like I said, you know, there can be a lot of bait and switch. You're told this is the group, and then suddenly you're dealing with a bunch of other people, and material is disappearing. And then by the time, unfortunately, with construction, and the majority of these projects are construction, a lot has disappeared by the time people actually start to realize. But if you have that monitoring, it would stop that. But let's just talk about the management. I have some very short notes on here about the what is this, you know, what is the background of these people that are handling the project? How many projects have they done? And how many have they done successfully? Are there criminal convictions? There should be a criminal conviction check on all of them, on every one of them. You know, have there been any SEC actions against them in other projects, right? Have there been lawsuits from private parties? Again, and were there any judgments against them? Because that goes to your reputation,
Yeah.
right? And, you know, just a couple of other things. And are there any investigations ongoing that we're aware of, or indictments against the people that are going to do the management?
Yeah, so obviously, I'm probably for Clem as well, and Sam, I want to hear from Sam. We get compliance certificates from all of the key persons in a deal, and that includes that they're not bad actors, which I hope they can certify, or they'll have to certify, and also that they have reviewed the PPM and that there's nothing in there that's false or misleading. Clem, do you do that?
Yeah, we do that. You know, it's part of our due diligence with respect to our PPM. I'm curious to hear Sam, as a proprietor of many regional centers that does deals for developers, how you vet projects and management team members.
Yeah, so we have 15 regional centers that cover 21 states, and so we see a lot of projects. We have a lot of active projects with investors across that footprint, and so there's kind of a two-piece system. One is the initial diligence of the project, so looking at, you know, the key offering documents, the business plan, the PPM, the subscription, the offering, who are the people involved, who are the different team members involved if we didn't work on the documentation ourselves, right? So going in, do the documents meet EB5 requirements, and is it a team that we feel comfortable that's going to be able to execute on the project itself? A lot of projects don't meet our criteria, and so they're not affiliated with any one of our regional centers. But the ones that do meet our criteria, once they become part of that regional center or become sponsored by one of those 15 licenses, annually USCIS requires you to file a compliance, kind of a 924A job kind of update that's actually coming due this December. It's every December is the filing, a month and a half or so after the fiscal year end with USCIS, and that details all the activity of projects that are active with investors under the regional center, what the status is on the job creation and number of investors and activity that's happening. We kind of go well above what that requires. That's a once-a-year report. We do quarterly compliance reports on all of our projects. So every quarter, we reach out to the sponsor, to the developer, and get an update on what money's been spent, where investor funds are at that time, if there are active investors in the project, are they in escrow, or has their capital actually gone into the project, what's their immigration status, and then we have a full securities compliance form with about 30 or so questions that they sign off on every quarter over the year. So it's not a once a year, you know, filing that's required by the government, but it's a quarterly check-in, and then any project that has an investor, at least one investor, we do a physical site visit. Someone from our team goes to the actual project site, no matter where it is, at least once a year for any project that has at least one active investor, so we can see what's happening. Is there, you know, is there actual construction? If someone said there was construction, what's actually happening, you know, in the dirt on site, right? So it's really important to go above what the government requires, because oftentimes, like, just getting a short email once a year and not having a physical presence to see what's happening, usually that's not going to be sufficient.
Could I ask an unfair question?
Only if it's not.
So Sam, the proposed integrity measures would require regional centers to certify as to securities compliance. Do you think that's feasible?
I don't think it's feasible. No, I don't.
That's the right answer.
No. No,
Unless you hire another law firm and they actually, how do you certify that somebody else's securities work is compliant? It's about due diligence. You have to kick every tire, turn over every document, virtually do the thing yourself. I think it's difficult.
So we're running out of time. Just want to open up the floor to one or two questions.
So
Can you get the microphone?
No, we need that. He's like right in the front.
So, when we are trying to, bring people from abroad, is there a minimum education qualification that the USCIS would need for them to be, considered for this category, EB5 category, or like a minimum bachelor's or a minimum master's, or is it okay if they,
To be an immigrant investor?
Yes.
No, not that I'm aware of.
No, there's not.
Thank you.
Good morning. My name is Ted Gilman. I own and operate a broker-dealer, and we are active in the EB5 space. Question about regional center registration. Currently, there are very few, if any, regional center sponsors that are registered investment advisors. Is this something anybody on the panel has looked at, and do you have any opinion as to whether or not regional centers should be either state or federally registered investment advisors?
Interesting question.
I think it depends on what they do, of course, right?
In most cases, the regional center isn't the one that's typically managing the funds, right? A lot of people think, oh, regional center, they raise the money, they're going to make the loan. The regional center is just a license, effectively a permit that allows you to sponsor a project for job creation. It's typically not that entity that's, managing the flow of funds and is subscribing investors. Oftentimes it can be the same group of principals as was mentioned earlier, but that entity itself, the purpose is not to orchestrate the flow of funds into a project. So a registered investment advisor typically relates to managing funds directly, and so regional center is typically not, that entity itself is not directly managing a pool of capital.
And for the NCE, I think now that they have a specific project, so they're not really doing that much advising, but once redeployment kicks in, that might become a greater issue.
It might become a greater issue if they don't already have authority to make reinvestment decisions, which is something that we're currently putting in our documents now to kind of cut off that issue.
But that's not the regional center
Again,
necessarily. That's
not
the new
the
commercial
regional-
enterprise,
that's the
right?
new commercial enterprise.
True. Although
To the extent
on a
that the general
variety-
partner of the regional center
a variety
is
of
the
ideals. Go ahead. You can make the point.
No, no, please. I'm sorry.
Well, I think we're going to wrap it up.
I would say this, though, with respect to regional centers becoming an RIA, I don't think that's necessarily appropriate because they don't give investment advice to individuals about making an investment. However, I am seeing a trend where regional centers are retaining broker-dealers and becoming registered representatives. And I'm seeing more regional centers utilize broker-dealers and or becoming broker-dealers themselves, which I think is more appropriate because they're raising money on behalf of others.
Right. I'd like to thank Clem, Brian, Ozzy,
Hi,
and Sam for being here.
I have one more question. I'm sorry.
Oh, there's two.
I've been waiting here. I mean, you didn't say me. Okay. I'm an immigration attorney. I've seen for many EB5 projects, the developers will guarantee that if the investor's I-526 is denied, they're going to reimburse the investor for their capital contribution. Do you think this kind of guarantee will raise a red flag from USCIS?
No.
That is allowed.
That's allowed?
That's allowed.
That's allowed.
Yeah.
Thank you very much.
Well, they guarantee the return of the funds to the NCE, not to the individual investor themselves. There's a distinction.
Very good
But the regional
explanation.
center can guarantee the refund if there is a denial of the 526. Because if there's a denial of the 526, the person isn't in the EB5 program.
That's correct. Yeah. Good point.
Yes.
It's tough to get around there.
Great.
Hey, Sam. My name's Gary Van Shafton, but do you accept the financial data that the developers send you on a quarterly basis?
Do we accept it?
Or do you have an internal audit group? Or?
Yeah, we have a separate compliance department that goes through the financials to make sure that we believe the financials and, you know, that something's actually happening there.
Good. Thank you.
Any more questions? No? All right, now I'd like to thank Claire, Brian, Ozzy,
Thank you.
Sam.
Thank you, everyone.